in our continuing series, View from the Other Side. We're very pleased to have with us today as our guest Irwin Karp. Mr. Karp is a graduate of City College of New York and Columbia Law School, where he was a member of the Columbia Law Review and Editorial Board. He later became a partner in a firm headed by Arthur Garfield Hayes, whom many of you may recognize as the co-founder and early general counsel of the American Civil Liberties Union. Mr. Karp represented the Authors League, the Authors Guild, and the Dramatists Guild for over 30 years. Mr. Karp rather modestly describes himself as having testified at Copyright Office and congressional hearings on the 1976 Copyright Revision Bill. Well, the truth of it is that if you go back to your offices and you get your copy of the statute and you hold it up to the light, you'll see fingerprints. Those are the fingerprints of Irwin Karp. Mr. Karp was a leading and influential participant not only throughout the revision process, but also throughout the process to develop the regulations that implemented the 76 Act. A few examples of sections of the statute where you'll find the fingerprints are the sections on duration, termination, and Section 118. He was also influential in our regulation implementing registration, especially with respect to divisibility. If you look at the announcement for that regulation in L 191, you'll see a reference to a, quote, persuasive, practical, and legal analysis that was submitted by Mr. Karp regarding registration and divisibility, and the Copyright Office went on to adopt his point of view. Other examples of Mr. Karp's contributions include the Cantu Guidelines on photocopying under interlibrary loan arrangements and the Guidelines for classroom copying in not-for-profit educational institutions. And this is an example where Mr. Karp's participation resulted in the absence of a provision. I believe he's largely responsible for the fact that Section 107, fair use, does not include a general educational exemption. Irwin was counsel in cases involving authors' rights, including Goodis versus United Artists Television, Breck versus Bentley, Hadley versus Commissioner of Internal Revenue, and Steinbeck versus DeRosa. He's presently the director of the National Committee for the Berne Convention, and I think that Irwin is living proof that one can be totally dedicated both to authors' rights and to First Amendment values. He has filed amicus briefs in many copyright and First Amendment cases, as well as in tax cases. His topic today is the role of the Authors League in copyright litigation and legislation. Please welcome Irwin Karp.
Thank you very much. I'm most happy to be here, and I'm very grateful to Jody for having invited me to give this talk about the Authors League's role in copyright litigation and legislation. I don't propose an intensive history of its activities, neither time nor patience, yours and mine, would allow that. But I will talk informally about some of the things the League did during the years I was its counsel, both in legislation and litigation. I'll touch on various provisions of the Copyright Act in numerical order and tell you something about what this authors group did on that subject, both in the Congress, in the Copyright Office proceedings, and sometimes in the courts. As Jody said, I graduated from Columbia Law School, where, unbeknownst to me at the time, I was already in the company of future copyright experts and specialists. I think some of them included a gentleman named Eugene Alenikoff, who was very active during copyright revision representing public broadcasting, Theodora Zavin, who was Assistant General Counsel of BMI, Chief Judge Feinberg of the Second Circuit, who wrote several copyright opinions, including Davis against DuPont, and Ted Kupferman, who worked for Warner Brothers for many years and went on to be a congressman, and now a judge on the appellate division of New York Supreme Court, where he has also written decisions involving literary property. At Columbia, I had no thought of getting into copyright. I didn't even know what copyright was. I'd never heard of it. And as I recall it, Columbia didn't offer any course on the subject, and I don't know that any of the other people I've mentioned were interested. I guess there may be one exception, that is the most foremost copyright graduate of Columbia Law School who followed me by a few years, named Barbara Ringer. Barbara might have known about copyright when she was in law school. I've never thought to ask her about that. I might mention that the Authors League of America was founded in 1912. Its founders were Winston Churchill and Theodore Roosevelt. It was not Sir Winston. It was a well-known in those days American author named Winston Churchill, who has long since been forgotten, and he was the first president. Roosevelt was the vice president of the Authors League. In the 1960s, the Authors League reorganized, became three organizations, one representing authors of books, the Authors Guild, the Dramatists Guild, and the League itself, which was an umbrella group representing the members of both guilds in matters of copyright, taxation, and freedom of expression. The presidents of the Authors League during the copyright revision years were first Rex Stout, the well-known mystery story writer, who was an excellent witness, Jerome Weidman, who wrote I Can Get It For You Wholesale and about 40 other novels, and lastly, John Hersey, the author of Hiroshima, The Wall, Bel Ferrandano, and many other books. And John was by far the most knowledgeable of the three about copyright and also the most dedicated. He was a member of Cantu and gave a lot of his time to that effort, and was also the author of a dissenting report in which he argued that computer software and other technological creative works really shouldn't be protected under the Copyright Act, that they required separate treatment. And I've noticed an increasing support for that view in recent years. I think John was rather prescient about it. Arthur Garfield Hayes was, as Jody mentioned, a well-known civil liberties lawyer. Some of you who have followed the Scopes trial might remember that Darrow was not the only lawyer at the trial. Actually, Hayes and another New York lawyer whose name now escapes me, he was became a famous divorce lawyer, were there, and Hayes did most of the legal work. Darrow tried the case, and Hayes drew all the papers, made the motions, and so forth. In the late 20s and 30s, he represented a number of book publishers and authors, including Horace Liverite, who was probably in his time the most talented publisher of serious American literature. One of Liverite's most distinguished authors was Theodore Dreiser. And Hayes spent a lot of time running around getting bans on Sister Carrie and An American Tragedy lifted, although Hayes usually tried to do it after the book had been banned for a few days, especially in Boston. He once sent a telegram to the lawyer in Boston saying, "Don't do anything about the ban until I get there," because it was very helpful to be able to advertise banned in Boston. Then he would get the ban removed. Arthur Hayes was also one of the early attorneys for the Authors League, and together with Billy Rose, late lamented songwriter and producer, and a partner of Hayes's named John Schulman, they organized the Songwriters Protective Association. And the Songwriters Protective Association, which decided that sounded too much like a longshoreman's group or the mafia, later changed its name to the American Guild of Authors and Composers, and I think it's now called the Songwriters Guild, if I'm not mistaken. But it is the same organization, and it was, too, quite active in copyright matters and in the revision program, now dedicated to preventing the passage of the Boucher Bill, among other things. There were several copyright lawyers with the Hayes firm. John Schulman was one of the senior partners, and John argued Whitmark against Fisher, the renewal case, and won it, but only in the circuit court, where Jerome Frank gave him a very strong opinion. It was then reversed in the Supreme Court, as some of you will remember, by a split vote. There were Edward Sargoy, who for many years was a distinguished copyright lawyer and practitioner in the motion picture field, had been with the firm. So had a gentleman named Bob Burton, who was at one point president of BMI. We also had, somewhat before my time, Nancy Wexler, who has been active in publishing and copyright matters for many years, and a gentleman named Richard Wincourt, who has written several books on the subject and was at the firm for part of the time I was there. Hayes ceased to represent the Authors League for a while, and he came back to it, or they came back to him in the 40s, I think. I think they came back to him before I joined the firm while I was still in the Army. And they did it because the Dramatists Guild had lost a very important antitrust suit called Ring Against Spinner. The Dramatists Guild had a relationship with Broadway producers which was no different than that of the stagehands or any other union. It was a real union management relationship, the kind every authors group would like to have, but can't. And a producer named Ring, a lawyer, sued the Guild for violating the antitrust laws on the strength of that contract, which was a closed-shop agreement with the producers. And the Guild lost its case in the district court. The district court held that the Guild was not a union because A, its members owned their copyrights, and B, they were not employees for hire. And there were the economic aspects of the relationship which served to distinguish it too. Hayes was called in along with Osmond Frankel, who happened to be Nancy Wexler's father and was a distinguished civil liberties lawyer in his own right. Frankel argued part of the Scottsboro Boys appeal and several other major civil rights cases in the Supreme Court. And they persuaded the Court of Appeals, which had already in a prior appeal ruled adversely to the Guild's claim of exemption from the antitrust laws as a union. Nonetheless, Hayes and Wexler persuaded the Court of Appeals to lift a permanent injunction against the Guild's use of a Guild contract. Ironically, that ban had been imposed by a judge named Simon Rifkin, who left the bench for a much more lucrative occupation. He became the senior partner in Paul Weiss, and that firm, as you know, has spent many a happy and profitable hour defending ASCAP against antitrust charges which really aren't too different than those leveled at the Dramatists Guild in the Columbia Broadcasting suit and in the Buffalo Broadcasting case. For several years, I had nothing to do with the Authors League when I was at the Hayes firm, but in around 1953, I began to work for them. And when Hayes died 2 or 3 years later, I became the League's counsel. As I recall, one of my first contacts with the copyright statute had to do with a new statute of limitations. I didn't go back to look at it. All I remember is it looked to me like it was all right, and I filed a statement in support of it for the League. And John Schulman, for some reason, thought it was terrible, and he disapproved of it in a statement for the songwriters. My first real encounter with the copyright community, which of course is heavily centered in New York and indeed was more so then, was at the Gotham Hotel. And there I met Herman Finkelstein and Sidney Kay and Horace Manges of Weil, Gottschall and Manges, who represented the Book Publishers Association, and Sargoy and many others. And they were all assembled there by a Warner Brothers attorney named Morris Ebenstein to support the defendants in Ballantine against De Silva, the famous renewal case. The Supreme Court had already held that an author's illegitimate children were entitled to the same renewal rights under state law in that jurisdiction as legitimate children. And all of these very experienced copyright lawyers thought the Supreme Court was wrong. They were meeting kind of late in the game because not only had the Supreme Court decided the case, that it already denied a petition for re-argument. And any sensible person would have thought enough was enough. But Ebenstein was quite a very interesting guy. I got to know a former lady friend of his who was the agent for the Brecht estate and brought me Brecht against Bentley, to which I will repair shortly. And she told me that Ebenstein was so taken by the movie version of the Maltese Falcon, and he was involved in the famous suits with CBS over the rights of Dashiell Hammett to use the characters subsequently in the CBS radio series. Ebenstein was so taken with the Maltese Falcon that when he took a nap in his office, he used to sprinkle paper around. That was what one of the characters in the Maltese Falcon did to prevent anybody from sneaking in on him while he was cooping in his office. Anyway, Ebenstein had found an ancient procedure called a writ for the redress of grievances. You remember that, Dorothy? I think that's what he called it. And we were really quite silly, and all these people enthusiastically said, yes, we'll support it. And I said, no, we're not going to support it. And I think that was the high point of my relationship with most of these people. It went downhill from there. Anyway, the Supreme Court, of course, rejected it. And bastards have been protected ever since, as I think they should have been. Toward the end of the 50s, I began to file amicus curiae briefs for the Authors League. One was in a case that didn't seem to get much attention. I don't think any of the music organizations filed, and it was called Biltmore Music Against Kittinger. I always say Kissinger, but it was Kittinger. And it had to do with whether the compulsory licensing provisions of the Copyright Act were triggered by a recording licensed abroad. I think it was a question of first impression, and the Ninth Circuit had said yes, and it seemed to me that was not a particularly good opinion for authors and publishers of music, but the Supreme Court would not take review. But at that point, most of the cases I was filing were really in the First Amendment area. There was a case called Butler against Michigan, which went to the Supreme Court on a children's obscenity statute, and then Roth against the United States, which was the landmark case in which the Supreme Court recognized the First Amendment implications of state and federal obscenity laws. It involved really two cases, one a state statute, one a federal statute. And in that case, I began to learn, and in subsequent ones, the need for some patience, because I think the process of defining obscenity went on for many more years, even than copyright revision. In my Roth brief, I argued that the court should hold that Congress and state legislatures had the power to deal with distribution of objectionable material to children, and that there was room for some regulation of distribution to adults where it was disseminated, when material was disseminated in such an obtrusive manner that it was thrust upon people who didn't want to receive it, but that for the rest, that there was a willing distributor and a willing audience, a willing reader, a willing viewer, that the First Amendment banned any restriction on distribution. And I kept repeating that in briefs for several years, and Justice Brennan, who was the expert on the subject, never bought that argument. It wasn't mine alone. I later discovered that Professor Emerson had adopted the same position early on in one of his famous articles on the First Amendment. But I hadn't been scholarly enough to know that. I had reinvented his wheel. And it was not until 17 years later, in a case called Miller against California, that Brennan finally threw up his hands and said, you can't formulate regulations that will still preserve First Amendment expression, freedom of expression. And he used that very same formula that I had put in my briefs and that Professor Emerson had advocated. But unfortunately, time had run out. Up until then, he had always been in the majority or a plurality, but this time he had run up against the Berger court, and he was now writing for a four-judge dissenting group. In the late 1950s, I really began my acquaintanceship with the Copyright Office. It was at a meeting in New York called by Arthur Fisher. I think it was one of his last official acts. It wasn't too much later that he died. My remembrance of times is dim now, but Fisher was well into the copyright, planning for his copyright revision program, and he assembled the New York contingent and outlined what he intended to do. And I sometimes wonder what copyright revision would have been like if Fisher had lived. I'm not sure it would have been as good from the author's point of view, and I have a hunch it would not have been anywhere near the open process that it was under the aegis of Register Kamenstein and Barbara Ringer. Because that whole process, while I think it went on too long, but unavoidably so, was really a model of a democratic discussion, where everybody had an input, and that carried over to the House and Senate, particularly the House proceedings, because they too were marked by that same ambiance. In the first stages of the revision program, as some of you will remember, those interested groups who were participating did so through comments on the various studies prepared by for the Copyright Office. Barbara's study on renewal, Alan Latman's studies, Mel Nimmer's, and others. At that point, as I do remember, Nimmer on copyright didn't exist. In fact, I remember the first time I saw Nimmer on copyright. It was in the study of Mel's house in Los Angeles, next to the UCLA campus. He had invited George Carey and I to dinner one night. We were all there at an ABA meeting. And there was Nimmer on copyright. It was all on 4x6 cards, though. And there were thousands of them all around the room in boxes. The room was just full of these boxes, which Mel was in the process of turning into that, I think it was 1960 was the first edition, a one-volume edition. I had joined the ABA after several years of practice without being the least bit interested in it, because I suspected that its copyright division or committee would have some input in the revision process, and I wanted to be there, keep an eye on all these other people, none of whom I trusted to treat authors with any kindness. And fortunately and unfortunately, the ABA was really sort of a paper tiger during revision. It had so many conflicting interests of different groups, and the copyright revision bill, both in the early drafts and later, was really a collection of entirely discrete provisions when you got to the economic rights, with some groups being interested in one or two, like the jukebox people, or the cable industry later on, and so forth, so that there were all sorts of conflicting views on the ABA committees. I think it should have, it might have done a much better job if it had just concentrated on the technical provisions, did a little homework and had some input on those. But as I recall, it really didn't. I think one of the next steps in the revision proceeding were the copyright extensions of the copyright term, the hearings and then the bills. And the first hearing was very interesting because you met John Philip Sousa's daughter, who was then 90, and a living example of someone who had outlived her father's copyrights. But ASCAP kept bringing her back for encores, and it really wasn't all that interesting after that. What the extension hearings really were, although some of us didn't realize it until later, were a tribute to the political clout of the Christian Science Church. I think if it hadn't been for them and for science and health, we probably wouldn't have had the extensions or as many of them as we did. And then, of course, we got a bill later. I remember that because I remember being in Paris in 1971 with Barbara and Kastenmeier and Judge then Congressman Mikva, when someone brought us word about the bill. And Kastenmeier said, well, one of you ought to oppose it. And we all said, but we want to get a copyright revision bill through. Why don't you oppose it? And he didn't answer that question. But actually, I later learned before the case went to court, in which the special bill for the Christian Science Church was declared unconstitutional, as I recall it, on church and state ground, that it probably was unconstitutional under the John Deere decision, which said Congress hasn't got the power under the copyright clause to rescue something that's already in or falling into the public domain. The next step were the Copyright Office hearings, which were very well attended and provided a very full discussion on most of the key points. I think some of us, had we had the foresight to see the footnotes in briefs and in opinions in Mills Music against Snyder, would have been much more careful the way we spoke at these meetings. I didn't do too badly because, for one thing, I urged that that the exception to termination for derivative works only apply to motion pictures. Indeed, that was all it was ever intended to do at the outset. The termination clauses in the copyright bill were the outcome of demands primarily by me and the Authors League that there be an effective termination provision. The Register had provided for a form of termination in the draft bills, but we thought it should be more effective. And we had a long series of negotiations with the distributor and user groups. I think the last one was in Arizona. We went out to Arizona in February. It was a midwinter meeting of the Bar Association. It was very disappointing. It was cold as hell out there in February when we were there anyway. And we did come to an agreement, and that agreement covered both termination and the definition of employee for hire in Section 101, which is now the subject of more controversy and some good and bad appellate court decisions. But in any event, you may remember that the district court judge in Mills Music used the testimony selectively. Where it suited his purpose, Judge Weinfeld would quote it, and where it didn't, he said, well, those were informal hearings. I don't really have to pay attention to what they've said. I think the circuit court decision in Mills Music was correct. I had filed an amicus brief in the circuit court, and indeed, one of the things that convinced me that sections 203 and 401 were not intended to allow a publisher to continue participating in the proceeds of a derivative rights license, such as Mills Music did in receiving a share of the monies paid by record companies, 400 of them from time to time, was the fact that Mel Nimmer and I, independently, had both written to Barbara and Cammie, pointing out that the first draft of the termination clauses only applied to exclusive licenses. That was all that an author would be able to terminate. And we both, Mel because he had grown up in the movie business and I because I was suspicious of publishers, said you can't trust them. What they'll do is take both an exclusive and a non-exclusive license, and then when the exclusive license is terminated, they'll still have the non-exclusive license and will be able to participate. And I referred to things like the proceeds from licenses they grant to record companies. And the Copyright Office changed the termination clause to make it apply to all licenses, and said in its comments, published comments, it was doing that to avoid this possibility that the publishers could participate, which to me made it quite clear that Mills Music wasn't intended by the Copyright Office, which was Congress in a sense, to get what it got out of a majority of the Supreme Court. At the House hearings, the Authors League was represented initially by some of its more prestigious members. Rick Stout, Hersey, Elizabeth Janeway testified, Herman Woke, and I think I had John Dos Passos down once too, and one or two others. But after that, after all of the fanfare of the opening hearings, I did most of the testifying, and I came back, as Jody indicated, on a few occasions on such things as fair use, library photocopying, and the manufacturing clause, which subject I became quite interested in. Actually, The revision hearings for us were interesting because the Authors League never had any money, and we never had a Washington lobbyist. And a lot of people got pretty healthy in the pocketbook in Washington, representing the music publishers and ASCAP, BMI, and the record industry and so forth. But we just didn't have the resources for that, and we did very little personal lobbying. Our whole case was presented at the hearings, and first at the Copyright Office hearings, and then at the legislative hearings. And I was impressed, and I've mentioned this more than once, at the fact that that subcommittee, particularly in the House, with Kastenmeier and Mikva and Ed Pattison and what's his name, the Republican from Illinois, Tom Railsback and others, they really listened. They were present at the hearings and they listened, and you could really get your points across to them. And most of the things that we had any, where we had an interest and we were making an effort to get something into the act or change something, we were successful, and it was not because of lobbying. It was basically because they were listening, and they were rather sympathetic to the author's point of view. I think it was an author-oriented committee, and I think things have changed a lot in Congress, not just because the committee is different, because the whole way of operating was different. One of the things then that struck me was that, by and large, with a few exceptions, what the subcommittee decided is what the Congress did. And you didn't have to worry about powerful interests running around telling congressmen if they didn't vote to this bill or that. Wait, for example, until you want us at election time and see how little exposure you get on the air. That ain't no way to lobby a source licensing bill, but that's the kind of thing that happens. And it happened with the manufacturing clause in '82, where the power that already existed in the '70s was now able to get the extension. I think one of the few visits I ever made to a congressman was to Senator Mathias, along with Hersey and Woke. And we saw the senator after the Senate had added his Section 118 to the Senate draft of the revision bill, granting a compulsory license to public broadcasting for musical, graphic, and literary, non-dramatic literary works. And he was very courteous, as he always is, and very affable. Talked to Hersey and to Woke about their books, and then I made a 10-minute presentation. He listened very quietly, and he smiled at me, and he said, "What's your fallback position?" He never discussed what I said. He wanted to know what our fallback position was, and I didn't have the wit or confidence to say the House of Representatives, which turned out to be the case, because he put it in, but the House took it out. We were doing more visiting, and again without lobbyists, in the tax area, because concurrently with the copyright revision hearings, and about that same time, we had two important tax measures. One was the outcome of the Congress adopting the Keogh bill, which allowed self-employed people to establish pension plans. And I remember going to American Book Publishers Council. That was the predecessor of the current AA, American Association of American Book Publishers. American Book Publishers Council annual meeting. In those days, they lived more modestly, and they didn't go to the Caribbean or someplace like. They all went to the Poconos, because that was close to New York. And I was on a panel with Horace Manges and a couple of other people. And when I finished, a partner of Horace's, one of his tax experts, named Ted Tannenwald, who's now has been a tax court judge for many years. Tannenwald said, "What do you think about the IRS position on authors and the Keogh plan?" I said, "Well, I don't know anything about it. We're very happy that the bill passed." And he said, "Well, the IRS says authors aren't entitled to deduct their contributions because royalties are not earned income," which was a real blow to us. And we went down to see Senator McCarthy, Gene, not Joe, Eugene McCarthy, and he called in Larry Woodworth, who was then the director of the Joint Committee on Internal Revenue Taxation. And we had a good meeting. but nothing happened. It took 2 months and nothing happened. In those days, I don't know where I got the idea that they ought to do it. If they're going to do it, it ought to happen in 2 months. So we went to see Keogh. We got an introduction to Keogh. And then within 2 months, Keogh amended the key section to include a definition that has been in the law ever since, holding that income earned by any self-employed taxpayer from the disposition of intangible property he creates or she creates is earned income. And then the Senate wrote a very important report on the nature of author's income, explaining why it's earned income rather than unearned income. And the other piece of legislation we were putting through then, with very little lobbying, just one visit to Keogh, never testified about it or anything else, was an amendment to the Social Security Act to provide that income from copyrights secured before a taxpayer was age 65 would not be included as earned income during any retirement year in which he worked or she worked. Until then, many authors were being denied benefits because while they continued to work, and they didn't earn income, but they were getting income, royalties and other income from earlier copyrights, before their copyrights obtained before their retirement. So those were our two achievements that gave us a little confidence while we were waiting for something to happen with the copyright bill. In fact, in 1976-77, we had to write 2 or 3 letters to the Social Security Administration to explain the difference between copyright on publication under the 1909 Act and the new laws so that they could adjust their regulations to take account of that. Turning to some of the provisions of the Act which involved the Authors League and authors, one, of course, is in Section 101. The definition of works made for hire, the second definition. And that was a compromise that should have precluded some of the decisions we've had in the area of independent contractors, where the Second Circuit and the Seventh Circuit have, I think, just ignored the congressional history and ignored the definition to hold works to be works for hire when the individual creator was not an employee in the sense of Clause 1. Work wasn't created in the scope of a real employment relationship. I think the Supreme Court is getting a chance to look at that, and on certiorari to a circuit which handed down contrary opinion which I believe is right, saying that the whole point of the second clause in the definition of works made for hire was to limit the status of a work in all of those areas to the particular exceptions listed, and not allow the courts to go out and create a quasi-employment relationship. Also, the definition of copies became important, because the next, I think one of the most major tax problems authors have faced since then was the result of a tax shelter amendment to the Internal Revenue Code, which aimed at preventing investors in motion picture tax shelters from writing off their expenses before the movie earned income. And in writing the clause, someone used the word books. The clause referred to expenses incurred in the creation of motion pictures, films, or books. And the IRS suddenly began denying current deductions to authors for expenses they had committed in the current tax year, and said you've got to allocate them over the life stream of the income from your book, and you can only deduct proportionately for each work the expenses allocated to it in each year that the book earns income. Well, I took that case for an author named Arthur Hadley, and we lost it in the tax court, and then I won it in the Court of Appeals. And a very important part of our case, of the argument I made in the Court of Appeals, was the meaning of the word book. Actually, the government never even looked in the dictionary, because even when you get to the dictionary, book isn't defined primarily as a work, literary work written by an author, bound copies. Way down the list comes also a literary manuscript. But the Copyright Act and the House Judiciary Committee report make a very sharp and affirmative distinction between a literary work and the copies in which it is reproduced, such as a book. A book is a copy, it's not the work. Anyway, we persuaded the court that because of this and other copyright elements and tax elements, it had to look at the legislative history very closely, and the legislative history was a committee report that dealt for 20 pages with tax shelters and never mentioned the word author once. Obviously, they weren't thinking of authors at all. They were thinking of investors in book tax shelters. And we won that case, which eliminates the obligation to capitalize up through 1980s, the end of 86, but that's now an open question again because of someone's midnight raid on the conference committee report on the 1986 tax reform bill, where gremlins inserted a footnote to the comment on the capitalization section, and the footnote says it also includes the expenses of writing and researching a book. And Senator Moynihan was on the conference committee, said, I never saw that footnote. I never voted for that. And I talked to most of the members of the conference committee, and they never saw it, which shouldn't surprise anybody who has any knowledge of how committee reports are written, including the House Judiciary Committee report. I think a lot of it was written by telephone with all kinds of people. But it turned out pretty good. Section 102, the subject matter of copyright, was not of great significance to us because I think it dealt quite correctly with the problem, except that I'm reminded that one of the occasions I visited the Copyright Office was a hearing on whether typeface should be copyrighted, which was brought back to mind when I was thinking about 102. And I remember Barbara quoting my testimony at her hearing to the House on why typeface should not be copyrighted. Well, I think are we facing some sort of a replay of that or a related issue about book design? I think there's some talk about trying to get copyright protection for book design. Section 107 I remember very well because I spent much more time with the American educational community than I ever would have wanted to do. We had endless meetings debating and trying to work out compromises on fair use and education. Ultimately, under some pushing from the subcommittee in the House, and particularly Father Drinan, I think he was the one who suggested it, or Kastmeyer, one or the other, we entered a series of negotiations to work out guidelines for classroom copying, and we did. And I'm beginning to think that guidelines have a lot to recommend them. And when I look at things like the Salinger case, I think we could do better with guidelines than we did with the decision by Judge Newman. And that's true, I think, of some of the other infringement and fair use cases. It might be a way somehow to have guidelines that are created under a procedure that's flexible and can be adjusted. And it might save a lot of time and a lot of misery for authors on both sides of the question. I left the Authors League and I parted company in October of '66, but I have been filing for other organizations since then. And in the Salinger case, I did file an amicus curiae brief in support of the Random House petition for cert on behalf of Hersey and Anthony Lucas, the author of Common Ground, and Hotchner of Hemingway against Hotchner. I had a little trouble getting Hotchner because he doesn't feel kindly to Random House. They sued him once under the satisfactory manuscript clause, which is a very touchy question for American authors, and he beat them. But he's a gracious man. He agreed to come on the brief even though he was helping Random House. We had Justin Kaplan, the famous Mark Twain biographer, and others, and we argued, or I argued, among other things, that if the court really read the Judiciary Committee report closely, they would find that publication was hardly the device which should trigger fair use or close the door to it, since some of you may remember that in the House report, there's a very strong statement about the archaic concept of publication. The biggest mistake in the 1909 Copyright Act, and it goes on to point out why publication is meaningless, and that the real question is dissemination. And I argued that since the Salinger letters obviously were now copyrighted under Section 303 or 2, I forget which one, that you couldn't use dissemination to deter, you couldn't use publication. You had to consider, were they legally disseminated? And they were, and were legally available to the author. Section 108 on library reproduction consumed, I think, about as much time as fair use for all of the groups involved on both sides of the issue. And the Authors League and the Association of American Publishers, primarily representing the copyright side, and the American Library Association, Association of Research Libraries, Special Library Association. Oh, the American Chemical Society, I think, was active, and the physics group, Bill Koch. And we met repeatedly. We had several meetings here in Washington at the Cosmos Club. We even had a meeting at Dumbarton Oaks, which elevated this question to a dignity much higher than it deserved. And that was very unproductive, at the one at Dumbarton Oaks. I think we almost broke up at Dumbarton Oaks, actually. And I made a big mistake. I had prevailed on Ogden Reed to introduce a bill I had written, which would have established a commission to study the question of library lending royalties. And in those days, it was called library lending royalties, although all it was the Scandinavian and British and German plan to pay royalties on the basis of library circulation from government-appropriated funds. It was not a copyright measure. And I had done this because there was a lot of talk in the author community about what the British were doing and why weren't we doing anything. So when you don't want to do anything, and we certainly didn't in the middle of copyright revision, the next thing you do is appoint a commission. And since I couldn't appoint a commission, I thought maybe we get Congress to do it. We got Reed to introduce the bill. And that was made public the day we were at Dumbarton Oaks, and I was accused by more than one librarian of trying to sneak something in and make them pay royalties for lending books. And I had just as much trouble explaining why that wasn't the case as I had explaining why they were wrong about library photocopying. Anyway, we worked toward some compromises, and we participated in the Cantu guidelines. And I guess one of the things I should mention about, as far as the Authors League's participation is concerned, we did participate very actively in the Williams and Wilkins suit, which had been brought by Alan Latman. I remember meeting with Alan and Horace Manges and Dan Lacey, who was then the executive director of the Book Publishers Association, to discuss with Alan the suit which he was planning. And at that point, the publishers were not particularly interested. But I was, and I thought Alan should go ahead with the suit. And there was a lot of discussion then and in the future about whether that was the right place to test library photocopying and the question of fair use. And I think Alan was right. His theory was that since the government couldn't be enjoined from using copyright, you had to sue the government under the special sections of the Judiciary Code, and all you could get was damages, that in effect the court could establish royalties for the future in the award by the method in which it awarded damages. And Alan, of course, won at the at the hearing judge's level in the Court of Claims. And then in the Court of Appeals, he asked me to argue one of the issues, which I did, so that he felt the court should know that authors were very much involved in the suit. And it was quite a disappointment. We had heard that we were likely to win in the Court of Appeals, and it went just the other way. And I always wondered how much talking Ben Kaplan at Harvard had done to Judge Cox, who was a friend of his. Not in any insidious way, but if Cox had learned copyright at the feet of Ben Kaplan, then you can understand why Williams and Wilkins was decided the way it was. In the Supreme Court, we had a 4-to-4 split, and I think if Blackmun had not recused himself, Latman would have won the case. And the whole shape of Section 108 would have been different, because then the librarians would have been asking for relief from a law that required them to pay royalties. I think my other contribution on the 108, well, there were several. We proposed language, some of which was put into the section, and so did the librarians. Some of theirs was put in. And I think I was one of those who was responsible for the concept of systematic copying. And it was sort of Freudian because one of the cases I had argued in the New York Court of Appeals against a publisher, albeit a vanity publisher, changed the law of punitive damages in New York. In order to get the court to hold that we could recover punitive damages for fraud, I had to make some sort of a compromise. I couldn't argue for it in every case because the court obviously wouldn't grant it. So I came up with the concept and alleged systematic fraud. And that came back to me when we were talking about photocopying, systematic photocopying. Divisibility of copyright, 201D. The Authors League had urged from the start that copyright should be identified as a divisible property, or actually a collection of individual rights. And one of the reasons we have been involved with this or aware of it was because the tax court and the IRS had long since recognized copyright as divisible for tax purposes in determining whether a transaction for the disposition of a given right, like a motion picture right, was a sale of property. And those decisions kept talking about divisibility. And then we got involved in Goodis against United Artists Television, which had been a suit brought by an author named David Goodis for infringement. The infringement was a television series called The Fugitive, produced by United Artists Television. And Goodis had serialized his novel in the Saturday Evening Post. He had had several serialized there. And some of them, although they weren't very good, weren't particularly of a high literary value, were very attractive to movie makers. And this novel was sold to Warner Brothers, which made a picture with Humphrey Bogart called Dark Passage. Another Goodis novel became Don't Shoot the Piano Player, a very famous French motion picture of some 30 years ago. And United Artists Television defended on several grounds, one of which involved the concept of divisibility, because they argued that the copyright notice in the Saturday Evening Post could not have secured copyright for Goodis's novel. He had not copyrighted it separately. This was the first publication. There was no separate notice, as there seldom was and seldom is in magazines of that kind. And they argued that the novel was in the public domain because Goodis retained the copyright and all of the rights except for serial rights. Therefore, the Saturday Evening Post couldn't have copyrighted his novel. And that was pretty much what the cases said. We came in on the appeal. Actually, Horace Manges was approached first, and he brought me in for the authors. And then we realized that the attorney for the plaintiff really knew little about copyright, and I offered to argue it. My fee was much lower than Horace's. I didn't charge fees in those days for things like that, and Weil Gottshaw was not quite that charitable, so I was the available copyright expert. And we won. We got a very good opinion on divisibility, and I think it's pretty much settled law. I think today there's one case on the West Coast, the Ninth Circuit, where the parties are going to re-argue both Goodis and Rohauer against Killian. The appeal is pending right now, brought by a man named Shelley Abend, who was like Rohauer, a collector of renewal rights in old novels so that he can claim against motion picture companies. I think my time has just about run out. One or two of the other things I might mention are 201E of the Copyright Act, which was our creation. When the Russians entered the UCC back in 1973, Andrei Sakharov and 5 other Russian intellectuals and dissidents warned that the Soviet Union might use the opportunity to appropriate foreign copyrights in the works of dissident authors, and then as copyright proprietor prohibit their publication abroad. And it sounded plausible to me, and I wrote a draft of what is now 201E, and persuaded Tom Brennan, who was then Senator McClellan's counsel, to put it into the act, and he persuaded McClellan to do it. In fact, years later, I hadn't been doing much research for this, but this popped to the surface. It's congressional record, and it's a 2-page statement by McClellan. We wrote him a letter, actually it was signed by Hersey, at the time of the Mathias Amendment, putting in 118, in which we reminded McClellan and Jackson, Senator Jackson, of our interest in preserving, the United States' interest, in preserving the freedom of authors, not only freedom of expression, but freedom to control their copyrights. And somehow I managed to draw a link, I don't know how plausible, between Section 201A and the Mathias Amendment. We said if we won't let the Russians appropriate copyrights, we shouldn't let public broadcasters do it either. The termination clause, I think I've talked more than enough about. Let's just say a word about the manufacturing clause, because that really was a long-time involvement. We had opposed the continuation of the manufacturing clause in the 1976 bill. Indeed, I had filed an amicus curiae brief in Hoffenberg against Kamenstein, which some of you may remember. It involved the novel Candy, which had been published abroad by Hoffenberg and I think Terry Southern. And it wasn't brought into the United States because it was considered obscene. In fact, it was published by Olympia Press in Paris, which per se made it obscene, even though it wasn't, because Olympia specialized in that kind of stuff. And they couldn't get it through customs, so they couldn't do an American edition within 6 months. And Charles Remboff, who I've done a lot of work with in the First Amendment area, represented Putnam's, and he sued Cammie to try to compel the issuance of a registration, arguing that the manufacturing clause didn't require the denial of registration if the work published abroad had never been imported into the United States and if the application was made for the first American edition, which I think may be right, and I think some people consider it still be an open question. In any event, in supporting his petition for certiorari, I argue that the manufacturing clause violated the Fifth Amendment because it denied American authors of literary works equal protection of laws. The Supreme Court didn't take the case, so no one ever had a chance to argue that. Then, during the hearings, the Authors League continued its outright opposition to the manufacturing clause, although the publishers had made a deal with the printers which would have accepted its continuation. Authors League also proposed, and I drafted, what is now 601B7, which creates an exemption for works of American authors that are published abroad. And the committee, especially the liberals on the committee, were very much anti-First Amendment. I remember Father Drinan wanting to know whether the manufacturing clause didn't violate the Helsinki Accord, among other things. And they voted, as you know, to terminate the clause on July 1, 1982. Then we had the hearings before the prior register, David Ladd, which were quite intensive and produced a very useful report recommending that the clause not be continued. But the political cloud of the book manufacturers, particularly Donnelly, and the unions led to the passage of the Extension Act. And I had testified on more than one occasion that we thought the manufacturing clause was unconstitutional. By now, I'd become, over the years, much more First Amendment conscious and argued that it also violated the First Amendment. The district court judge sat for 9 months and then said, no, it didn't. And his whole opinion is basically, no, it didn't. Plus a very good opinion for us on standing to sue, because that was government's big challenge was whether we had standing to sue. I brought this case for the Authors League as representative of its members. It's really a representative action, and book publishers did too. And I was a plaintiff only because we decided it would be easier to use a pamphlet I had written and copyrighted than to try to get a book published abroad and brought in as a test vehicle. In fact, I tried to convince Leonard Feist to let me use a book he had written. And I tried to explain to him even though he was then famous, his fame might dim, but if he were the plaintiff in Feist against the United States, he'd be remembered forever. But he wouldn't do it, although he's the one that arranged for the pamphlet to be printed in England. He got a British music publisher to do it, so that we could bring the suit. Then in the Court of Appeals, the district court decision was affirmed, but Judge Oakes actually concluded that the manufacturing clause does violate the First Amendment. He said pretty clearly in his mind it does, but exercising judicial discretion, he was not going to decide it in this case because the clause was due to expire and was then 86. Took quite more time than we expected to get there. And the other two judges decided it was constitutional for reasons that were almost as convincing for my case as Judge Oakes' opinion, because they said it's true that the clause does impose a restraint on the distribution of a whole class of work, and that could raise serious First Amendment problems, but it doesn't, because all an author has to do to avoid that restraint is abandon his or her copyright. And that came just about the time Justice O'Connor was writing that copyright is the engine of free expression, making clear that this circular argument made no sense at all. And if you had to give up your copyright, in very many cases you would be giving up your right to distribute the book because no one would publish it here without a copyright. So that I thought we came out pretty well, considering that the manufacturing clause expired in 86, but that had nothing to do with any of what I've told you. The manufacturing clause was defeated because the European community, as some of you know, already angry at Congress and us for extending the clause in 82, and already having gotten a GATT decision that we violated GATT by doing so, the community took much more direct action. They issued a boycott list and said that if Congress extended the manufacturing clause again, or made it permanent, the new bill was going to make it permanent, they would boycott above more than $500 million of American goods. And they listed what they were going to boycott. Most of it had nothing to do with copyright. We now have a new set of bills pending, one by Senator Simon and his colleague from Dixon, I beg your pardon, Dixon, from Illinois, the home of the Donnelly Company. And I understand Thurman is going to introduce a new bill, too. So I may be able to finally argue this again in the Supreme Court. I almost hope the bills pass, only for that reason. Thanks very much. I don't think we have time for questions. I'll take them, but if you're too late, I'll forego them.
We can have some questions.
Okay.
Irwin,
Yeah.
you referred to the important agreement that was reached, I guess, in the early 60s about the termination provisions in Section 101. And as you said, the Section 101 issue is very live right now. The definition of work for hire, because the Supreme Court has asked the government for views as to whether certiorari should be granted in the Easter Seal case. So anyway, is there any sort of record of that decision or that discussion that one could use as part of the legislative history?
Dorothy, I'm just not sure. I know that no record was kept of. I remember the meeting in Arizona. A lot of people, a long table in a sunlit room, but I don't think anybody took kept notes. The only record would be a private record, I think, other than what may have been said in some of your hearings afterward. And I'd have to go back and look. I'm not sure.
Yeah, I haven't checked that either yet, but I have a feeling it'll be similar to what was said about the termination provisions, and maybe somewhat inconclusive in the view of the court.
Of course, it has no significance, but I was convinced and said to other people, and other people told me, we agreed that this should have eliminated much of the confusion over works made for hire, that it really was now limited, A, to true employment relationship, and B, to those special situations provided for in the second clause. contributions, educational texts, things like that.
The Second Circuit, in justifying its decision, Alden basically indicated that there was nothing in the legislative history to suggest that Congress intended to depart from the common law concept of employee, and they felt they could continue to use the precedents that had been developed. And I'm struck by the fact that those precedents were really developed between 66 and 1976. In other words, they were developed after the compromise that you referred to. And if there isn't any record of that compromise, then, what about the argument of the court that the Brattleboro case, the picture music versus Bourne case, those cases show what the law was in 76, and Congress did not indicate that there was to be any departure from that in the legislative history.
So the Fifth Circuit doesn't, was it the Fifth Circuit?
Yeah, Fifth Circuit.
They don't agree with that, do they?
No, they don't, but they're not very, they're a bit ambivalent too, I think, because they went off on the concept of joint authorship. I wondered if you had any thoughts about that. I was very interested in their view that in almost every case where under the Second Circuit's reasoning, the commissioning party might be the employer, under the Fifth Circuit reasoning, the commissioning party would be an author, a joint author. So that you'd have two authors. It wouldn't be just a work for hire. You'd have the commissioning party as the author. The Fifth Circuit was clearly willing to hold Easter Seal Society was an author, as a joint author of joint work. And I wonder if that isn't a more disturbing analysis for authors in general than the Alden decision on work for hire.
It could be in some cases. I think but the Alden Spiegel, many of the elements factors that the court cited as supporting its conclusion really, the plaintiff, whoever, what plaintiff, kept saying, I helped design it. So he sounded like he could be co-author.
That's what the court said. Speaker, I ran into the circuit.
Well, the Cochran bill, which might solve this, but I don't think that's politically feasible. I don't think it's going to go anywhere.